Counsel, I drafted at least the first iteration of instructions. It was based primarily on what was used the first time around, together with some obvious changes, as well as a couple of additional requested. So before we go on the record, Ms. Ellenwood, Mr. Kaiser, are there instructions that you don't think should be in there or additional requested?
Thank you, Judge. Yes, we did find that we had requested in October of 2018 a modified 755B regarding intoxication not being a defense. And
I apparently didn't give it though, because it wasn't in at least what I pulled as my final draft. So again, not saying we can't this time, but
we are requesting it.
okay, thank you.
Other than that, Judge, in our first run through, we didn't find anything else we wanted to change. Oh, just that. Did the court receive our request, which I think is today, regarding 175 motive?
On motive, and I did, and I read the comments to it, Mr. Kaiser, and I didn't really think it applied, but you can enlighten me of what I'm missing.
The bracketed portion says where intent is the issue, then you should give the whole thing.
Right.
And then the non-bracketed portion is when intent's not the issue. So this isn't an intent crime, it's a reckless crime. So that's why we felt that since it was an intent crime, that the remainder of it would apply to a reckless crime. And certainly there is some awareness that's part of the mental state required in the reckless crime. And finally, we felt that even without the word intent, in other words, we as lawyers think about intent and knowledge and all that, that it would still be something that jurors as lay people, unless they're told they don't have to find a reason, they might yet still feel that they have to find a reason. And our position is there doesn't have to be one.
All right, and again, I saw it really late in the morning and read the comments, but again, we certainly can take a second look at that. Mr. Gray, before I ask for your informal thoughts and comments, do you want me to give 315 where your client elects not to testify? Because the only way I give that is if you request it. And I can't remember what page it's on, but
I saw it here.
Right after credibility, so it would be after the 300 instruction. About 6 pages from the back.
I see it. I'm looking at it, Judge.
Yeah, and that's only given if you request it. That's why it's in bold.
Yes, I do want to.
All right, so 315 is in, and obviously it's not going to be bold type, but I did that so that I would
Let me talk
remember.
to the client for a minute.
Yeah. And Mr. Kaiser, that motive instruction was what? I didn't write it down.
It's 175, Judge.
Thanks, Judge.
Or lack thereof, I guess is the better instruction.
Yes.
No, we don't want it.
You don't want, okay. 315 is out. As to the balance, Mr. Gray, are there instructions that you wanted or that maybe you requested first go around? And I'll be honest, I didn't go back to see what everyone had submitted first trial, so I'm basing kind of things
Just the
on.
instructions I wanted.
Correct, if there are any additional requested.
No, Your Honor.
All right. As to those that I have drafted, and I'm going to exclude the state's 2 additional requested, the intoxication and the motive, are there instructions there that you're going to at least want me to review that I've included currently?
Yes.
Okay.
I'll get to that. Well, to start off with, Your Honor, verdict 1 and the instruction on that, let me see. It's page, it's 990, using or possessing a dangerous weapon. It's page 1 or 2. And then in the verdict it says, did Kayle Fleischauer commit the crime of using a dangerous weapon? I object to 990 be given to the jury in that paragraph. And I discussed this with my client. He's willing to waive a jury, and this is a penalty phase. This is a penalty.
Correct.
And he's
But it's
willing-
also an element the state would have to prove.
Absolutely.
Yes, and we will waive a jury on that penalty issue and have the court decide that if in fact they find him guilty of this crime. Otherwise, it makes no sense, and I don't want this jury to say, well, we'll find him guilty, but we'll just say he won't use a gun. That makes no sense, because all three pathologists said, no, the cause of death was gunshot to the head. So I asked the court to, so that the jury doesn't get confused with that, to allow us to waive a jury, because it's a penalty phase, and let the court decide it if we lose. And I'm sure the court will decide that he did use a gun, because it's obvious that the individual was shot with a gun and it killed him. So I wait.
So what you're telling me then is that your client is prepared to waive a jury determination on that issue, and that would be, then I guess, is under you're not willing, and here's my distinction. Generally, when a element is waived, it is conceded. And I don't hear you saying that. You're not conceding it. You're simply saying we don't want the jury to decide it, we want the court to decide it.
That's correct. And it's a penalty phase.
Well, well, it's not penalty phase, because this is a separate element. This isn't like proving, second or third OWI, which goes to penalties. This is an element of the crime. So Ms. Ellenwood, Mr. Kaiser, the defense's request to waive jury trial on that issue and have that matter determined by the court?
Can we wait 1 second?
Sure.
Judge, I'm going to take this in the nature of a question to the state of whether or not the state's willing to waive jury trial and have a bench trial. And the state is willing to have a bench trial on that element. Obviously, it requires a lengthy colloquy, which we'll have to do.
Right.
But if that's the case, I do need the defense to waive any argument that they might make that when this case was open to the jury and the court read the charges, the court read that it was well armed. And I can't have an appellate issue later that you decided armed or not armed. And now they're mad on appeal because initially the jury was told that this was a well-armed case. So in the process of the colloquy with the defendant waiving jury trial in this element, I think we need to have him waive any appellate rights that he might otherwise think he has on the issue of the jury being told it's well-armed.
And that appears to make at least practical sense to me, Mr. Kaiser, because you are correct that when we screened the jury, that was the charge that was read. Now, certainly, we're all aware of cases where, albeit once the state rests, there can be motions to, modify based on the proof. And in that scenario, I guess I can analogize that to, okay, the jury was told X, but now they're being instructed on Y. Does that create an appellate issue or not? But I agree that if there's going to be a waiver, I'll inquire so as to make the record and I think satisfy the state's concerns. So we'll take that up then, and arguably then 990 is out, as well as a special question will be off of the verdict. Going forward, Mr. Gray, any other instructions that you want me to review or reconsider?
Yes, Your Honor, 180, it's almost at the end, statements of Kayle Fleischauer. You have a credibility page before that, 300, and in 180, you highlight my client as by stating, on the third termination here, whether the statement or any part of it ought to be believed. And I think that's an unfair highlight of my client's statement, like I didn't kill my son Chase. You're pointing out whether it ought to be believed. The first, whether a statement was made, whether the statement actually restated here at trial is accurate, I don't mind those, but this one goes to the credibility of the statement, and I object to it. It highlights it.
Your Honor, it's the standard instruction, and every portion of the jury instruction in an attempt to direct the jury to a proper legal conclusion does highlight some portion of testimony. I don't think this is any more prejudicial than any other part of it.
I'll take a look at the pattern, but I tend to agree with the state that these tend to be instructions that have been tested, tried, and are true, at least as I'm using that particular analysis. And having sat on that committee for 10 years and chaired it, I am certainly cognizant of the work that they do and the efforts that go into those processes. So I'll take a look at any comments, Mr. Gray, to see if in fact that has been raised at an appellate issue, because if it was, I can guarantee you it would be in a comment, because they don't miss anything when it comes to comments. But I'll note your concern about that particular bullet point, and I'll be prepared to rule tomorrow morning once I've done my additional analysis.
That's it, except what? Could I have overnight to determine 315?
Yes.
Could I have overnight?
Yeah, and I didn't want to spring that on you, Mr. Gray. That's why I brought it to your attention, because had your client testified, there is likewise an instruction in 300 that I would have given. That one's not optional, but this one has to be, is given only at the request of the defense, and I know you only had 30 seconds to talk to your client about it, so I certainly will give you until tomorrow morning, just before we bring the jury in, because it's simply something I can edit in or edit out of my script.
I'm sorry.
As to requested instruction on motive, and do you have a copy of 175, Mr. Gray?
Oh, yeah.
I'll get you one.
Given him the last time?
We did not.
It's.
I don't know if it was requested or not.
Well, it was because first degree intentional homicide is an intentional crime. It was in there.
Well, point well taken, Mr. Kaiser. Okay, so I need,
What number is it, Judge?
it's 175. But I'll print you off the full one, because that's the state's request, Mr. Gray, so just give me a moment here. I just realized that that's not the full instruction. While we're looking at that one, Mr. Gray, the state had requested in trial 1 and is requesting the intoxication basically can't be used as a defense, I think is the gist of that instruction. Under 755B.
I have it here, Judge.
Okay.
We're not going to use that, and it's not an issue in this case.
No, but him being intoxicated is an issue in this case, and we don't believe the jury should go unguided on the question of whether or not they can decide he was too drunk to have known what he was doing.
Okay, let's take up 175 first, Mr. Gray. There, obviously, first parenthetical is not, and the second one obviously is a little wide open, as the parenthetical says, use the following in all cases where an instruction on motive is believed to be appropriate. So I guess the is believed is my discretion is what that's suggesting, but Any objection to that one?
The ones, which,
175. And it would just be the last paragraph.
well, I guess I object to it because it doesn't say that motive, lack of motive is, well, let me think.
Think about it, because again, I just got it this morning, and we can take it up tomorrow morning, Mr. Gray. I don't want to spring it on you unfairly, so take a look at it. I'm inclined to give it, but I certainly am willing to entertain any thoughts that you have once you've had a chance to look at it, as well as the comments. 755B modified, let me pull up the actual.
Judge, just momentarily, and I apologize for interrupting, but I did have it drafted for the charges last time. And so it should read, and I apologize for this, with the mental state required for the charged offense.
Are you waiting for me, Judge?
No, I'm trying to analyze the request of 755B, because the actual instruction is for involuntary intoxication. And so this is obviously then an edit of the pattern, which suggests just the opposite, so to speak, of what the instruction speaks to. Again, take a look at it, Mr. Gray. I'll decide in the morning. I will at least somewhat tip my hand, but I certainly want to think about it, and I'm not going to be bound by the tip. That if it's argued, Mr. Kaiser, I probably would give it as a curative instruction. If it's not being argued, then I probably will not give it. So that's at least me thinking out loud. And again, I will reconsider, but I want at least to suggest that Mr. Gray said, well, I'm not going to be arguing it. And if I hold, well, and I understand that.
Just my one sentence.
What did my grandmother used to say? Many a slip between the cup and the lip. So, man, so I'm just saying that.
Just my one sentence, Judge. It goes to the third element, that Kayle Fleischauer was aware that his conduct created unreasonable substantial risk. And my concern is that jurors with experience with intoxicated people, even at that level, may not think they're aware of anything. And so,
regardless of whether he argues it or not, you think we should include it?
We've seen jurors be concerned about things that
Okay.
not argue.
I'll consider that as well, and be prepared to rule on it early tomorrow morning. So those are the instructions that we'll look at, and you'll have your final iteration tomorrow morning when I give you my decisions. Verdict forms, again, with the understanding I'm going to take out the question. Any objection to the verdict forms, Mr. Kaiser?
No, they look good.
Mr. Gray?
No, Your Honor. On the decision not to testify, Kayle Fleischauer's decision must not be considered by you in any way, and then in the federal one, it must not be discussed in any manner, and must not influence your verdict in any manner. If you did give it, could you put that part in there? Must not be discussed in any manner, because it's important. They're not supposed to even talk about it.
No objection.
Thank you. So if you can get me that, Mr. Gray, or have someone write it up and submit it, then I make sure I capture it, as opposed to relying on my memory. Back on, record should reflect that we're outside the presence of the jury. I've conducted what I characterize as a informal discussion with counsel regarding instructions and verdict forms. First, as everyone is aware, when this case was presented to the jury as part of the voir dire, the court did inform the jury relative to the charge of second-degree reckless homicide by use of a dangerous weapon. As a result, the court was prepared to include 990, which is using or possessing a dangerous weapon, which is an element that the state would have to prove in order for the penalty enhancer to apply. In our conversation off the record, Mr. Gray offered that his client was prepared to waive a jury determination on that special question and have that matter submitted to the court Likewise, the state indicated, while off the record, that they would agree to that element being submitted to the court and not to the jury, but also suggested that as part of my discussion with Mr. Fleischauer, as this is his right, not his attorney's, that he likewise would waive any appellate or challenge to the fact that this was screened with the jury prior to the actual selection. As I indicated to counsel during that informal discussion, the court, not routinely, but periodically, will modify charges to reflect the evidence. That's generally at the request of the state at the conclusion of a case where they make a motion that the evidence, or strike that the crimes conform to the evidence, and the court, again, not routinely but periodically, then does change a substantive crime to reflect the proof as opposed to what was screened with the jury. I think this is somewhat in the same boat, but I, again, am likewise of the opinion that if I get a waiver from Mr. Fleischauer, which I've not tried yet, that it should include that reference as part of the voir dire. So all that being said, Mr. Gray, it is your request and your client's request that the use of a dangerous weapon element be submitted to the court only and not decided by the jury. Is that correct?
Yes, Your Honor, and I've discussed that with Mr. Fleischauer.
So Mr. Fleischauer, again, similar to our discussion earlier today, the decision is yours. It's not your attorney's, and while Mr. Gray can give you advice, you also have the right to reject that advice, to say no, in spite of what you're suggesting to me, counsel, or despite what others may suggest to me, I understand that this is my right and no one else's. So again, sir, under our law, a jury of your peers, in other words, the 12 jurors who will ultimately decide this case, would be asked whether the state has proven beyond a reasonable doubt, which again is the burden that applies, whether you committed the crime of second-degree reckless homicide while using a dangerous weapon. Now, they only answer that question if they in fact have found you guilty of that offense. Do you understand that?
Yes.
So that question is included on that verdict form. Certainly if they find you not guilty, they don't have to answer that question. But that is an element. In other words, that's an essential component of this crime that the state has to prove to these 12 citizens beyond a reasonable doubt that you did commit. Do you understand that?
Yes.
And because this is a criminal case against Mr. Fleischauer, all 12 jurors would have to agree on the answer to that question. So if 11 say yes, 1 says no, I cannot accept that verdict, albeit a clear majority. Do you understand that?
Yes.
So the requirement that they be unanimous applies to that question as it does to the underlying crime. Do you understand that?
Yes.
Now, by your attorney indicating to me that it's your decision to not have the jury decide that, it would be then my determination, once the jury has returned a verdict, to make that decision. Do you understand that?
Yes.
Again, I have to be satisfied to that same degree of proof, beyond a reasonable doubt, that you did commit the crime while armed with a dangerous weapon. So the burden of proof doesn't change. It's simply one person deciding it as opposed to 12. Do you understand that?
Yes.
And is that your choice to give up a jury determination on that special question?
Yes.
Has anyone, again, forced or pressured you to make that decision?
No.
Anyone promised you anything?
No.
And again, Mr. Fleischauer, because we had a lunch hour, have you used any alcoholic beverages, illegal drugs, or prescription medications since I last spoke with you?
No.
Are you under the influence of any of those substances at this time?
No.
Anything changed relative to your education, your understanding of the English language, or your ability to understand me from when we first discussed these topics?
No, sir.
And you're making that decision of your own free will?
Yes.
Understanding you can reject your attorney's advice, reject family's advice, friends' advice, is that correct?
Yes.
Are you satisfied with Mr. Gray's representation on that topic?
Yes.
Also, Mr. Fleischauer, as I said, when we introduced this case to the jury last Monday, I included that particular fragment of the sentence for the crime. In other words, I told the jury that you had been charged with second-degree reckless homicide while armed with a dangerous weapon. Do you recall that?
Yes.
And we screened the jury with the understanding that would be the crime that would be at issue here. However, as I instruct juries, they are to base their decisions on the facts and the law that I instruct them on once the case is concluded, meaning tomorrow morning. It's those series of instructions, those descriptions that will guide them and that they will be asked to decide. You understand that?
Yes.
So I have every confidence that they can set aside, because also, as you hopefully recall, in my screening of the jury, I told them several times that anything I said during that process of jury selection, anything that the attorney said during the process of jury selection, were not facts, and they were totally to disregard it and begin their consideration of this case when that first witness was sworn. Do you recall that? I am a ardent and strong believer in the ability of juries to follow instructions and to accept the instructions that the court provides to them. So I have every confidence that, albeit mentioned as part of jury selection, not being mentioned as part now of the ultimate charge to the jury, will be of no consequence. But, as Mr. Kaiser said, we try to avoid issues as best we can, and I trust you appreciate that as well, correct?
Yes.
So in addition to giving up your right to have the jury decide that element, use of a dangerous weapon, are you also waiving or giving up any challenge to an appellate court, meaning the Court of Appeals or the Wisconsin Supreme Court, on the fact that I screened the jury for that particular element but will not now be instructing them on that? Do you waive that as well?
Yes.
And again, has anyone forced or pressured you to make that decision?
No.
Anything promised to you?
No.
Satisfied with Mr. Gray's representation?
Yes.
Mr. Kaiser, satisfied with the colloquy?
I am, Your Honor. Thank you.
Thank you. Court first will find that Mr. Fleischauer freely, voluntarily, and knowingly waives his right to have the jury determine whether he was armed with a dangerous weapon at the time of the commission of this alleged crime. As indicated, that is a question that applies only to a finding of guilt, but is an element that is required to be found by a jury unanimously and proven by the state beyond a reasonable doubt. I'm satisfied that he's making a free, voluntary, and knowing decision. That decision is his alone, but clearly based on comments and counsel of his attorney, I believe, although I'm not going to inquire whether there's been conversation or counsel on that topic. But I am, as I said, satisfied that he's making a free, voluntary, and knowing choice. The burden of proof still remains with the state. There will be no additional evidence, and the court will, if asked to, make that decision on the record that was made during this trial, and that will be made after a verdict is returned by the jury if necessary. Likewise, based on that, the court will, at this time, give the following instructions: 100 opening, 1060 second-degree reckless homicide, 140 burden of proof and presumption of innocence, 145 information not evidence, 103 evidence defined, 170 circumstantial evidence, 154 summary of evidence, 161 agreed testimony, 162 agreed facts, 157 remarks of counsel, 155 exhibits, 158 recordings played to the jury, 148 objections of counsel, 147 improper questions, 150 stricken testimony, 190 weight of evidence, 195 jurors' knowledge, 300 credibility of witnesses without the parenthetical, as Mr. Fleischauer has exercised his right not to testify. 315 has been requested, I believe, by the defense with the inclusion of an additional phrase that Mr. Gray has offered as part of the federal instruction, and that will be drafted, submitted to the state, and at least as offered orally, the state did not object to that modification of 315. However, I'll confirm tomorrow morning with Mr. Gray that in fact he wants that instruction given. 180 statements of Kayle Fleischauer. Mr. Gray has challenged the third bullet point. The court has reserved, indicating it would review the comments in any case law and then give a decision tomorrow morning before we begin the instructions and closing arguments. 605 was a requested instruction by the state. There is no objection. 200, opinion testimony general. 205, opinion testimony hypothetical questions, followed by 160, closing arguments. 460, closing instruction. 482, verdict submitted, single count. 515, unanimous verdict and selection of presiding juror. And upon return of a verdict, 525A, the alternative form for instruction after verdict received. Instructions which the court has reserved on and which it will review during the break and prior to tomorrow morning is a modified 755B requested by the state regarding intoxication, and also 175 motive without the inclusion of the intent. And Mr. Gray will have an opportunity to review that and weigh in tomorrow morning. He objects, I know, to 755B, the intoxication modified instruction. And again, the court will review that and tell everyone tomorrow morning what my decision is. Are there any additional requested from the state or objections to those instructions the court has indicated it plans to give Mr. Kaiser?
Your Honor, no objection. Just as a courtesy to the court, I'll be doing rebuttal, not the settlement.
Thank you. And Mr. Gray, any additional requested or objections to the proposed instructions as identified?
No, Your Honor.
Thank you. Counsel, also I want you to be mindful of the fact that my general practice is not to send any exhibits back to the jury unless requested. And I mention that to you because there are differing practices, I know, throughout the state and maybe even in this county. So I don't want you to be caught off guard by not arguing a particular exhibit that you believe may merit emphasis or consideration, thinking it was going to go back to the jury. So if there are exhibits that you wish to bring to the jury's attention, you should reference those in your closings because, again, unless requested or unless agreed to, nothing will be going back to them. Anything else today, Mr. Kaiser, Ms. Ellenwood, before we adjourn?
No, Your Honor, thank you.
Mr. Gray.
And if they request transcripts, they don't go back.
Correct, unless there's portions of transcripts they want read by my co-reporter, which I'm going to consider very carefully. I know that reference have been made to other transcripts throughout the trial. Only those portions as used can likewise be used in any closing argument, so let's not get sidelined by reference to a transcript. Only those portions identified were considered or should be considered as evidence, but nothing from trial one certainly is going to go back to the jury. And if there's requests for read back or otherwise, I'll take that up with counsel, but my general admonition is they have to rely on their collective memory.
And our position will be that's why we asked for the instruction at the beginning that we do, so that we're not in that position.
Thank you.
Thank you, Judge.
Mr. Gray, anything else?
No, Your Honor.
Thank
No.
you.
Thank
Is
you.
everyone back here by 8:30 ready to go?
Thank you, Judge.
We can sleep in, Judge.
Pardon me?
We can sleep in.
There you go.